Yeah, we are live, David. We can
Okay,
start the session.
Honorable My Lord the Chief Justice, Honorable Judges, respected senior advocates, members of the bar, teachers, law students, and dear friends. It is our great pleasure to welcome each one of you to the online lecture series being conducted by the Kerala State Unit of the Indian Law Institute. The previous lecture series by several eminent personalities, both from within and outside the field of law, had garnered great appreciation, and we have an equally reputed speaker joining us today. It is my duty today to welcome the august gathering that are present, even though in the virtual mode. At the outset, I extend a warm welcome to my Lord the Chief Justice, Honorable Mr. Justice S. Manikumar. It is also my pleasure to welcome the Executive Chairman of the Kerala State Unit of the Indian Law Institute, Honorable Mr. Justice Alexander Thomas, and all the other Honorable Judges of the High Court of Kerala. We are also happy to note the presence of several respected senior advocates, law teachers, and law students, and several lawyers, and it is indeed a pleasure and honor to welcome each one of you. Moving on to my duty to welcome the speaker for today, it is indeed a matter of great joy for me to welcome Senior Advocate Mr. Arvind Dattar to our lecture series. Mr. Dattar is a prominent and highly sought after senior counsel with decades of extensive practice spread across several high courts in the country and the Honorable Supreme Court also. After being designated a senior advocate by the Madras High Court in the year 1999, Mr. Dattar rose to prominence and is an authority, especially in taxation matters and company law matters. His legal acumen in taxation laws was the reason why he was requested to be the revising editor for the book on income tax, Kanga and Palkiwala's The Law and Practice of Income Tax. Mr. Dattar is an academician and a lawyer combined together. His interpretative skills in constitutional adjudication are well known. His dedication to the profession of law is beyond compare in modern days of legal practice. He is a mix of conservative advocate who upholds tradition and ethical practice with modernity by being abreast of the latest. He never compromises either in his conduct or in his submissions. He has returned briefs and refused engagements of great monetary benefit because he stood by his beliefs. Apart from his professional capabilities, Mr. Dattar is an exceptionally unassuming person. All those who have interacted with him or who have briefed him were unanimous in their opinion that it was indeed a sheer pleasure to brief Senior Counsel Mr. Dattar. It is my singular honor, sir, and privilege to welcome Senior Advocate Arvind Dattar to this online lecture series. I request Advocate Krishna to introduce the topic for today's lecture.
Thank you, Vina. Being the largest democracies in the world, India and America are intertwined in their pursuit to balance individual liberty and national prosperity. As early as in 1947, Justice Felix Frankfurter of the US Supreme Court advised Sir B.N. Rao to delete the words due process of law from the text of India's draft constitution. Our nation makers heeded to the advice to pave a different path for constitutional liberty, yet acknowledging that the US Constitution should be studied not for a wholesome adoption, but for the judicious adaptation of its provisions, keeping in mind our unique circumstances. Since then, American jurisprudence has cast an irresistible sway over India's judicial thought and development. The preamble of both documents start with the same three stirring words, we the people, a phrase that confers equality, humility, and self-possession all at once. Indian Constitution has also adapted the thought propounded by the founding father of American Constitution, Thomas Jefferson, that process of amendment should be flexible so as to conform with the Jeffersonian idea that each generation should be free to adapt the Constitution to the conditions of its time. I'm sure this lecture would enlighten us as how a unique Indian Constitution came into the fore with the influence of American model of law. Similarly with Canada, India shares a history of Commonwealth influence in an ever-globalizing world. The provisions of a federation with a strong center, residuary powers of the center, and advisory jurisdictions of the apex court can all be attributed to a Canadian influence. Tracing the contemporary constitutional developments in both these jurisdictions will no doubt enrich your understanding and interaction with our own constitution. And there's no one better to delve into this topic than Sri Arvind Datta, who has penned a compendious article on the influence of American and Canadian constitutional laws on the Indian Constitution. Without much ado, I most humbly invite Sri Arvind Datta to deliver the lecture on the topic Insights and Perspectives on American and Canadian constitutional laws and its relevance to Indian public law. Sir, please.
My Lord, the Chief Justice Manikumar, Justice Alexander Thomas, learned judges of the Kerala High Court, my colleagues at the bar, students, members of various law faculties, ladies and gentlemen. I must thank the Indian Law Institute, the Kerala unit of the Indian Law Institute, for inviting me to speak on this topic. I must thank them for understanding my difficulties and giving me some more time to give this lecture. When I was first discussing with Mr. Shyam Mohan about the topic, I happened to be doing one case where we had to refer to certain Canadian cases. And I thought that it would be appropriate to discuss what is the contribution of Canadian law to India, what is the contribution of US law to India. Due to time constraints, I have not touched upon the contribution of law of Australia, which has played a role in interstate trade and commerce. So I've just confined myself to two jurisdictions, that is the Canadian Constitution and the US Constitution, and what is its impact as far as India is concerned. Before I start, I must thank Mr. Enoch David for the very, very generous compliments he has paid to me. I hope I deserve them. And when I heard about the very, very enlightened audience which is going to listen to this lecture, I must mention that there is some amount of trepidation about what I'm going to speak. Now, I'll first start off. One more thing I must mention before I start was that when I was preparing for this research with some wonderful interns, I found that there's so much of material. I never knew that there's so much of material on hand. And it would not do justice to the topic if I simply spoke for 30 minutes at a stretch without any kind of background material. So I've taken the trouble of preparing some slides, which I hope will be useful. And if the organizers want, they can mail the slides to you. You can use them if you like. If anybody have any questions, please ask them. So I straight away go on to my topic. And I first taking, though the title says American and Canadian constitutional laws, I'll start off with the Canadian law. Now, as far as the Canadian constitutional law is concerned, you had the British North America Act of 1867. And among the various constitutions, India has a closer similarity to the British North America Act. In fact, if you see the Government of India Act of 1935, you will find that the same concept of a federal legislature or provincial legislature, the items which are conferred on in Canada, they call it Dominion list. Here we call it the federal list, now the Union list. And some topics are given to the state list. One important point is that the lists in the Government of India Act and now the Constitution are much more elaborate than the provisions of the Canadian Constitution under Section 91 or 92. They have only 3 items in the concurrent list. And those of you who want to make a note, concurrent list comes in 94 capital A and 95 of the Canadian. Now it's called the Constitution Act of 1867. So there are 94A and 95 deal with the concurrent list. And it also says that in the event of any conflict, repugnancy, obviously the Dominion list or the federal list will prevail. So this is the basic point. And our own constitution has noted, our own lawmakers have noted, the federal court has noted that we borrow heavily from the Canadian Constitution when the Government of India Act was drafted. They say that when the Government of India Act was drafted by the British Parliament in 1935, they drew heavily upon the structure, the architecture of what is the British North America Act. Can I go to the next slide, please? Yes. Now, one very important contribution of the Canadian Constitution is the distribution of legislative power between the center, list 1, list 2, and list 3. And of particular importance is entry 97, which is the residuary power. And that must be read, as you know, with Article 248. Now, this judgment of Union of India versus Dhillon, here what happened was they levied tax on agricultural land, wealth tax on agricultural land. And the Punjab and Haryana High Court, a full bench of 5 judges, by 4:1, they said that that particular provision was bad. Now, it came to the Supreme Court, and by of 7 judges, and by a majority of 4:3, they upheld this particular power. Those of you who are making notes, just note entry 86 says that taxation on capital value of assets other than agricultural land. Now, the argument was, if agricultural land is excluded in the entry 86, can it be taxed under entry 97? And for the purpose of my talk, I'm not getting into this Dhillon's case, but I wanted to mention that in the main judgment of Justice Sikri, Chief Justice Sikri, there's extensive reference to Canadian judgments, how the lists are to be interpreted, how the concurrent list and how the residuary power has to be taken note of has been discussed. But in my humble opinion, the majority is wrong, is incorrect. And if those of you are interested, should read the dissenting opinion of Justice Shelat, who made it very clear that if a particular item has been excluded in list 1, then you can't then justify legislative power under entry 97. But for the purpose of this lecture, Canadian judgments have been extensively referred to in the distribution of legislative power. Of course, subsequently, if you go to Hext Pharmaceuticals and other judgments, wherever there is a discussion of Article 245, 246, List 1, List 2, List 3, etc., they have referred to the Canadian judgments. Please, next slide. Now, a very important contribution which Canadian law has made is the doctrine of pith and substance. And one of the outstanding judgments of the federal court is Subramanian Chettiar versus Muthuswamy Gounder, where it related to debt relief. And there, the Privy Council said, the Privy Council decisions from Canada, from Canada, they used to go to the Privy Council. Now, of course, they've got their own Supreme Court. But earlier, many judgments would go to the Privy Council on Canadian constitutional law. And there are important judgments. All of us know Attorney General for Canada versus Attorney General Ontario. Then the aspect theory cases, all of them went to Privy Council. The federal court remarks that because the structure of the Government of India Act and the Indian Constitution is similar, the Canadian principles are entitled to greatest weight. I'm sorry, it's height, it should be weight. And they serve as a very useful guide for this particular purpose. Then you next go to A.S. Krishna's case, where there's again case came from Madras, where they explain how this doctrine had been evolved. The judgment of T.S. Venkatarama here has very nicely explained how this particular doctrine has come. If you're interested, it's in paragraph 8 of this particular judgment. Next slide. Now, one latest contribution of aspect theory is from Canada. And this judgment is a landmark ruling of 7 judges. The majority judgment is by Justice Venkatchelaya. And the concurring view of Justice Ranganathan is equally important. Sadly, he passed away this morning at 12:30 a.m. One of our very, very great judges. Those who are interested, please see his dissenting opinion in the Antule judgment. I think, if I'm not mistaken, from para 142 to 192, 50 paragraphs, he dissented from the majority view, and it's a masterpiece by itself. Coming back to aspect theory, in the Federation of Hotel case, what they did was they levied expenditure tax if you spend money in expensive hotels. So Mr. Palkhiwala argued that this is nothing but in pith and substance, a luxury tax. It should come under entry 62, it can't come under this. He said, yes, you can levy expenditure on all. There was an expenditure tax act for some time. It was on all kinds of expenditure. There's no problem. But if you tax only an expensive item like a 5-star hotel or a luxury, then it amounts to a luxury tax. In pith and substance, it comes under entry 62 of list 2, and cannot be done. Then they said, no, they evolved the aspect theory. And when I spoke to Justice Venkatchelaya in some other context, he said they were struggling to get over Palkhiwala's arguments. And then Mr. Parasaran referred to this Canadian Constitution. And he said that we are not taxing the luxury, we are taxing the expenditure aspect of it. And they applied the aspect theory. In my humble opinion, this is a wrong application. Aspect theory should have no place in the Indian constitutional law, but unfortunately it has been applied. For example, in the case of service tax on leasing transactions. Now, lease is deemed to be a sale by the 46th Amendment. So in pith and substance, when you tax a lease, you are levying sales tax. Simple as that. Now, it is also settled by the Supreme Court that when you levy sales tax, you are levying tax on the principal component and on the interest component. In a leasing transaction, hire purchase transaction, in the EMI, monthly installment you pay, there is a principal component and an interest component. And the value of sale includes everything. Now, once it is taxed as sale, you can't levy service tax on the interest portion. But the Supreme Court in All India Federation case said, no, interest aspect can be taxed separately. According to me, that's completely wrong. There is no time to get into this, but this is an unfortunate point which should not have come. I personally feel we should go by the pith and substance theory. If a leasing transaction is in pith and substance, a sale, and it's a sale levy subject to sales tax, it can come only under list 2. You can't again levy it on the interest part. Similarly, profession tax, it's coming under entry 60 of list 2. Tax a profession. Now, you can't say that profession tax is paid whether or not I become an advocate or I practice in the court. When I do actual service, I am rendering profession tax. It's completely wrong. The right approach is by Justice Chinnappa Reddy in this International Tourist Corporation case. Those of you interested can note down, it is AIR 1981 Supreme Court, page 774. There, Justice Chinnappa Reddy says how to interpret the list. He says, go to list 2. All of us studied in law college that lists should be given a liberal interpretation. Now, if you liberally interpret list 2, if what is sought to be taxed or what is sought to be legislated can come within the liberal interpretation of list 2, then it can't be taxed under entry 97. This is the clear judgment, which unfortunately was distinguished and followed. But aspect theory is a Canadian concept which should not be applied, is my humble opinion. I hope sometime there's a 7-judge bench which overrules this. God knows what will happen in the future. Thank you. Next slide, please. This is a very important one. Proportionality. In the case of R versus Oakes, there was a case of proportionality, and that concept has now been imported into India. And if you see the aspect of proportionality in R versus Oakes, how did this proportionality come? Very interestingly, they said that for narcotic cases, the burden of proof shifts to the accused. Accused has to prove his innocence. That was struck down as being violative of Section 11D of the Charter of Freedoms of Canada. And they laid down 3 tests of proportionality that has been referred to in modern dental college. Justice Sikri has very nicely explained the concept of proportionality. And those of you interested can see there's a separate book by Aaron Barak, the Chief Justice of Israel, a very beautiful book on proportionality. So we get from Canada, we get pith and substance, we get aspect theory, we get proportionality. All these concepts have come in from the Canadian Constitution. Next slide, please. Hate speech. Now, coming to recent times, there is what is called the Watcott rationale. There were some speeches or some social media, etc., against immigrants. And then the Canadian Constitution laid down what are the tests which amount to hate speech. And they said that a speech will be treated as hateful if it leads to vilification of a class of people or leads other people to detest that class. So that is the 2-stage test which was given for hate speech, and that has been followed in Pravasi Bhalai, which deals with migrant labor, interstate migrant labor. So this concept of a very good discussion on what amounts to hate speech, how it should be not be encouraged. So there's a kind of a objective test laid down as to what amounts to hate speech. Next. Yes. Now, this is also a doctrine of indirect discrimination. It's a very interesting concept laid down in the Ontario human rights case. This was applied where women were recruited into the armed forces. And they said that, look, you can't disallow women from entering the armed forces. Now, indirect discrimination. So when you use indirect, automatically you think of direct. So the Canadian Constitution, Supreme Court says direct is something which is patently obvious. You can easily see this is direct. But when you go to indirect, it is latent. It apparently looks like it is equal, but actually when you examine it in detail, it amounts to indirect discrimination. These are very interesting concepts, but due to constraints of time, I am not getting into them. So this is another interesting doctrine of a recent origin which we have got. You'll find that this pith and substance, etc., has come much earlier, but in the last few years, hate speech, indirect discrimination, we have borrowed from, we have taken the help of, or at least used these constitutional cases from Canada as our basis. In fact, I'll also mention, before we just go to the previous slide, in the tribunal's case, which I had argued for Madras Bar Association, and Justice Rohinton Nariman's concurring view in the judgment, which he struck down the National Tax Tribunal Act. There, what happened was, they said that there'll be a national tax tribunal. The High Court's jurisdiction in all taxes, direct, indirect, will completely go. It will all go to the National Tax Tribunal. Now, there is extensive discussion in Canada on what is the role of tribunals vis-a-vis courts. And one interesting case I must point out, look at the approach. Unfortunately, our Supreme Court has given much more leeway to the government to get into tribunals, which in my humble opinion was a wrong step. But anyway, in Canada, there is a judgment called in re residential tenancies. In re residential tenancies. There was a huge housing shortage. There were a lot of rent control cases, more than 100,000 cases pending in Canada. It was a serious problem. So they formed what is called a Green Commission. Mr. Green was the chairperson. He formed a commission and he said, look, there are too many rent control cases. Why don't we start rent control tribunals manned by a judicial member, technical member, etc. So the load from the courts are taken away and the tribunals can decide the matter. And usual thing, tribunals are faster. There are no strict rules of evidence. It'll be cheaper justice. All these usual arguments are made. In an outstanding judgment of 7 judges, they said judicial power can never go outside the judiciary. And in fact, the UK Supreme Court has held there can be overlap between legislative power and executive power. We didn't talk of separation of powers. We said there is no strict separation, there can be some overlapping. But the UK Supreme Court has held that there can be overlapping between legislative and executive power, but they cannot be a mixture of judicial power with other powers. So the Canadian Supreme Court said, if you've got too many rent control cases, the solution is start more civil courts to deal with this problem. You can't say that because the courts are flooded, I will start tribunals and then allow them to be manned by retired civil servants and so on. That's not possible. So Justice Nariman has extensively referred to, there are 4 Canadian Supreme Court judgments on what is tribunals, quasi-judicial power, etc. And he eventually struck that thing down. I forgot to mention it here, but it just occurred to me that we were held enormously by the Canadian judgments in striking down the National Tax Tribunal case. Otherwise, see, now company law has gone straight to the Supreme Court. If tax tribunal had gone, there'll be no tax at all in any high court. And I had remarked at that time when arguing the case, I said that you'll have a situation where judges will go to the Supreme Court who have never dealt with the company law and never dealt with tax, because all tax cases have gone to the Supreme Court. But luckily that was at least struck down and the tax jurisdiction of the high courts has been preserved. Incidentally, our basic argument of the Madras Bar Association was high courts decide substantial questions of law in tax matters. 260A, central excise, only substantial question. The tribunal decides other matters. So I said that this is a core judicial power which can never go outside the judiciary. And I used the Canadian judgments for that and we succeeded. Next. Next, please. Yes, I have now, whatever interesting articles, I have put them on the slide. Those who want to follow it, these are interesting points which more elaborate. Those who are interested in going more deep into the Canadian aspects of what Canadian contribution is can read these 2 slides, 8 and next 2 pages. I've just collected, my interns have collected these slides, this research material which can be useful. Next, please. Next. Yes. Now, yes, that's it. Next, please. Now I go to the US Constitution. There has been a large number of cases of the where we have referred to US Constitution. In fact, we are doing some research and we find that author like Willis, I mean, we all referred to Cooley on Constitution, referred to Rothschaffer. These are all authors we have referred to. Recently, we referred to Lawrence Tribe. Then you got Mark Tushnet, who's written on comparative constitutional law. But an author like Willis on constitutional law has been referred to in 25 Supreme Court judgments and 106 High Court judgments. Just to give you a flavor that there has been extensive reference to US constitutional law in our High Courts and in our Supreme Court. Now, if you go to the US Constitution, we have a large number of similarities between the US Constitution and our Constitution. For example, I've just mentioned the 8th Amendment, which 8th Amendment was relied upon by the Maneka Gandhi in saying that human dignity is a facet of Article 21. But before I go to that, there are a large number of similarities. Take the First Amendment. It talks of freedom of, it says state can't support any religion. Freedom of speech is there in First Amendment. But there is the freedom of speech is absolute. Here we got 19.1a subject to 19.2. You got the Fourth Amendment, which we relied upon in the Puttaswamy case on privacy, that every home is secure. So privacy principles came from Fourth Amendment. Fifth Amendment is no person can be punished twice, no double jeopardy. You can't be compelled to a witness against yourself. So Article 20 takes this place, has got some bearings on the Fifth Amendment. Then, of course, 14th Amendment is due process, which we all have discussed a number of times. And so there is extensive reference to the statutory provisions of the US Constitution, which we have taken, particularly the amendments. And of course, the most important thing, not only for India, but throughout the world, is Chief Justice Marshall's Marbury versus Madison, where he said that ultimately the Constitution is what the court declares it to be. We are the ultimate interpreters of what the Constitution means. The legislature can draft what it wants, but what it means is for the courts to eventually decide. This, I think, perhaps is one judgment which has preserved democracy in almost the entire civilized world, the right of judicial review. And at the end of it, it is not the legislature, not the judiciary, not the executive, but it's the Constitution which is supreme. Next. Now, what are the US principles which are there? Yes. Now, if you go to particularly the second case, MPV Sundaramaya's case, Justice Venkatramaya rightly points out that our Constitution was not a tabula rasa. It was not written like the US Constitution. They didn't go to a particular place and draft our Constitution and so on. Here, we had the Government of India Act. Right? If you take Article 245, is nothing but Section 99 of the Government of India Act in a modified form. You take 246 is Section 100. You take similar articles, they will have a comparison with the Government of India Act. What has been added primarily are the provisions relating to fundamental rights, directive principles, and large changes have taken place in the legislative lists. See, obviously, there was no provision regarding foreign relation. All that has come as a Republican Constitution, which was not there earlier. So he says that we should apply the US Constitution with caution. Don't simply blindly apply it. Apply it with caution, because when the Government of India Act was drafted, a lot of trouble went into the drafting of the Government of India Act. And I may just share an interesting story. When I was recently working while updating my book on the commentary on entry 97, the Government of India Act 1935 had no entry 97. There was no residuary power to the federal government. And why was that? I believe the majority minority communities had great difference of opinion on whether residuary power should be given to the federal list, should it be given to the state list, provinces, what should be done. So finally, the UK Parliament came to a compromise. They said, we won't give it to the union, we won't give it to the provinces, we will confer it to the Viceroy. And the Viceroy, the Governor General, was given the power under Section 104. He had the power, residuary power, to make any law which is not mentioned in List 1 or List 2, yes, or List 3. So, coming to this, back to US Constitution, he says, take the US Constitution, apply it with great care. Yes, please go further. Next. In fact, before going to this slide, now that I remember, yes, sorry, Now, Arup Bhuyan is a case where they said you can't have guilt by association. They referred to some US case where they apply it, but there's no discussion why they are taking the US Constitution. They simply say, yeah, this is the position in the US. In Brandenburg's case, they're applying it. But there's a huge, still unsettled principle. It's pending before 5 judges now. Article 13 says that if a law contravenes Part 3, it shall be void. Now, what do you mean by void? Is it void? Is it voidable? Is it void ab initio? Right from Keshav Madhav Menon, if you go on this thing, as far as pre-constitutional laws are concerned, there is no problem. The moment the constitution comes into force, to the extent of inconsistency, it is no longer valid. But the difficulty comes after 1950, even now. Let us say, for example, a law is passed in 2015. It is challenged in, let's say, in the Kerala High Court. It's a Kerala law. For whatever reason, it ultimately comes for final hearing in 2022 and is struck down. Now, what is the effect of such a declaration? When does it take place? Does it mean that the law is invalid, void ab initio? If the answer is yes, what happened to all the things which took place between 2015 and 2022? Because there was no stay, the act was valid, there's a presumption that the constitution is valid. And all the acts done in that particular point of time, what happens to them? So the UK courts they don't have this constitution, but in administrative law, they could have delegated legislation. They've evolved a theory of a second actor. That is, all acts done when the law was valid, was operational, will be preserved. They will not be affected. And the striking down will operate prospectively. We've got a doctrine of prospective overruling, but prospective overruling is overruling a judgment. You can't prospectively overrule a statute. You may say, okay, fine, the invalidity is from this day onwards. But in discussing voidable, Keshav Madhav Menon, Behram Pesikaka, then you have Deep Chand, Mahendralal Jaini, then you have L. Jagannath versus Land Revenue, all the line of cases from 1950, the last case is 1972, where there's some courts say a law struck down is void ab initio. They refer to some US Constitution, US authors which say a law is stillborn. It has no life. It is wrong. A very good article came. He said if the law is stillborn, today if a law is struck down, it can be placed in 9th schedule and it will be valid, it will be immune from challenge. If it is stillborn, then there is no law at all. Where's the question of putting it there? Suppose it is stillborn by a single judge, struck down by a single judge, it's stillborn. What happens in the writ appeal? What happens in Supreme Court? So this theory of stillborn is wrong. But the point I'm making is the entire basis of what is a void ab initio law, what is a void law, what's a voidable law, all has been discussed from the US Constitution. Of course, later from 1948, they have taken a lot of material from Wade also on this particular aspect. So there's a huge body of literature, Article 13, Article 14, on the concept of voidness. Yes, and now it will be decided by a bench of 5 judges in the Supreme Court. Next, please. Yes, now just go to specific doctrines and specific tests. Police power. You see, in the US Constitution, they have kept this police power as a special power. There's some kind of residuary legislative power is there, where the states can use police powers, the quote-unquote police powers, to preserve morals for the good of society, etc. In Kameshwar Prasad, they said, sorry, we have got 245, we have got 246, we got elaborate lists. So there is no inherent legislative power. There must be a power. You make a law, then you implement it. There is no police power over and above what is mentioned in these lists. So this police power has been rejected as far as the India is concerned. So they specifically said, yes, this principle is applicable, this principle is not applicable. Then take Patuma's case, which is again from Kerala, where they make it very clear that in interpreting the 7 freedoms, the US test of reasonableness will not apply. It's a nice judgment by 7 judges. And they say that in our Article 19, we ourselves have got various restrictions. So let us not incorporate US tests of reasonableness into our law. Similarly, you go to strict scrutiny test, intermediate scrutiny test, all these have been rejected. In Saurabh Chaudhary's case, we deal with the admissions issues. So police power rejected, reasonable test rejected, strict scrutiny test. All these three tests applicable in US law has been decisively rejected in this, by the Indian Supreme Court. Yes. Due process. Yes. Now this is of course a subject matter of a book. In fact, there's a wonderful book by Dr. Abhinav Chandrachud on due process. Now there is a famous story. It should be Sir B.N. Rao. Sorry, it's not Sri B. Sir Benegal Rao. A huge story that B.N. Rao met Justice Frankfurter and he said, for God's sake, don't put due process. It was created a lot of problems in the US Constitution, so don't have process. And then there is a discussion, especially in A.K. Gopal and all this point, saying that we deliberately avoided due process. And when we say Article 21 says, no person shall be deprived of life or liberty except by the procedure established by law. That procedure established by law doesn't involve due process. So this is the way it went on. And finally, that of course the shift came in bank nationalization case and Maneka Gandhi and all that. But the entire due process comes from the 14th Amendment, and it has led to so much of legal discussion in India. In Puttaswamy, those of you interested, I have made a note of the paragraphs. If you take Justice Chandrachud's judgment in Puttaswamy, it's a very good summary. If you just note down, paras 273 to 288 deal with substantive. The topic starts with substantive due process, but 273 to 288 talks of procedural due process. 273 to 288 procedural due process, but 289 to 296 deals with substantive due process. And the very important point is, Justice Chandrachud refers to the decision of Justice Chalameshwar in Rajbala's case and says substantive due process cannot be a ground to invalidate a primary legislation. You can't invalidate that. Of course, the question is, can you use substantive due process to invalidate delegated legislation? That still is open. Maybe the Kerala High Court or some other High Court will deal with it. The procedural due process has been discussed in Sunil Batra's case, Krishna's judgment. It has also discussed. Now, please go to the next. Now, freedom of speech, commercial speech. Apart from Indian Express, you got Hamdard Dawakhana, you got other cases where a lot of US constitutional cases have been referred to while dealing with Article 19 cases. And as I said, in the Patuma's case, they made it very clear that what is reasonable restriction in terms of 19(1)(a) will not be tested by US principles, but by Article 19(2). Yes, next. Please go to the next. Yeah, no, right to privacy. Yes. In my view, one of the outstanding judgments of the Indian Supreme Court is the dissenting view of Justice Subbarao in Khadak Singh's case, where he says the whole of India can be a prison, etc. This was a case where there was surveillance of history sheeters. The majority upheld it, but Subbarao said, no, this is violating the right to privacy. And when we argued this Puttaswamy case, we referred extensively to US cases, right from the first case, where the famous judgment which said that the right to privacy includes the right to be left alone. Then you had the Katz versus US and so on and so forth, how privacy went on, that where there was a case where a person's was in the case of in the US prohibition, there used to be a lot of sale of illicit liquor. So a person is to go to a public booth, discuss how the liquor will be seen. So that was bugged. That was held to be unconstitutional. They said unless there's a warrant, you can't do, because a man is completely free to say what he wants. And finally, in Puttaswamy's case, we evolved the three principles of personal privacy, decisional autonomy, and the third principle, the decisional autonomy, personal privacy, and your physical privacy. That is, your body can't be harmed. Those three principles of privacy were laid down in Puttaswamy, and you will find an elaborate discussion of the US Supreme Court also in Puttaswamy. Next. Yes. Affirmative action. Again, this is an ongoing problem. We now have before the Supreme Court 10% for EWS, whether it can cross the 50% limit. Then again, we have got the Article 340, the decisions regarding the reservation issues that are going to come up. E.V. Chinnaya was there. If my memory serves me right, that's also gone to 7 judges. And the affirmative action in Chinnaya, they adopted the minority view in Jennifer Gratz versus Bollinger. Gratz versus Bollinger is a famous case on reservations in the US universities. And there they adopted the minority view was taken in Chinnaya's case. Yes. Next. Yes. So these are all the things. I think I've taken almost 35 minutes across my thing. And I must thank my 2 interns, Ms. Janani and Ms. Paridhi Jain, who did extensive research. Janani did the entire research on the US Constitution and Paridhi on the Canadian Constitution. I thank them so much for making this slide presentation useful. I said that I'll speak for about 30 minutes. My apologies, I've overshot the limit by 5. But there's so much to discuss on both Canada and US Supreme Court, how those laws have been discussed. And for the reason, the method which I saw which adopted was, first take the Indian statute, take a corresponding US statute, see how these provisions are. In the Company Law Tribunal's case, we showed the provisions of the Administrative Agencies Act. In the USA, they're called administrative agencies. They're not called tribunals. So what were the provisions? Then we use that Marathon Oil Company case to India and say, look, this is a ground for striking down the company law legislation. So I think if the statutory provisions are similar, or if the constitutional provisions are similar, then you can definitely adopt those principles and see and apply it here. And as Mrs. Krishna mentioned, ultimately it is we the people for liberty, equality, fraternity, for equal justice for all, and so on. So if a US judgment, if a Canadian judgment can be used to interpret, to preserve the great values in our preamble, I think it should be followed. With these few words, I thank the Indian Law Institute for giving this opportunity, and I wish all of you all the very best. Thank you so much.
Thank you, sir. Thank you so much for that enlightening address. So now we'll be having the question and answer session. We have a few questions here, sir.
Yes. Can you just speak a bit loudly, ma'am? Mrs. Krishna, can you speak a bit loudly?
Yes, sir. Yes, sir. Am I audible now, sir?
Yeah, yes.
Yes, okay. Sir, Advocate Vinu has raised a question. Do you think that due process, which Felix Frankfurter had cautioned against and was not in the Constitution, was brought in through constitutional interpretation?
Yes, it was. In Maneka Gandhi almost, it has been brought in through constitutional interpretation. First, there was if you see the history, in for example, in A.K. Gopalan, they say each article is a separate silo and they can't be this thing. That was taken away by bank nationalization. They said these are all interdependent. Each article can be read in the context of the other. And that has been definitely brought in by... Then in Maneka Gandhi, they applied the 8th Amendment. They said human dignity, there is procedural due process, and various judgments by Justice Bhagwati and Krishna and so on, they really expanded it, relying on due process. The entire scope of natural justice was also expanded through the process of, through the introduction of due process. Now, in right to privacy, since you asked this question, one question asked to us by the bench was that, where will you place right to privacy? You got all US constitutional principles is okay. Where do you place it? In 14, 19, 21, where do you get privacy? Because it's nowhere in the Constitution. And we said that it is permeates throughout Part 3, and we relied on a famous judgment of Justice Matthew, where he says there are core rights and there's a penumbra around it. So the right will be more effective when you take into account the penumbra. So I said that some of the fundamental rights, and other people also argued, they said some of the fundamental rights will have no meaning unless right to privacy is included in the Part 3 itself. And that's what the Supreme Court says. The right to privacy is Part 3. In fact, it went to 9 judges because the Attorney General argued we don't have a right to privacy in India, relying on some older judgments, and that has been overruled now. So to answer this question, due process has been included in our thing, but in Puttaswamy, they said substantive due process cannot be applied, but procedural due process can be applied.
Thank you, sir. There's another question by another viewer, sir. Can you please explain why aspect theory has no applicability in the context of Indian Constitution?
Yes. Now, we have got the pith and substance. When does aspect theory come? When does this problem come? When a central law is made and we say it overlaps with the state law. A classic example is service tax versus sales tax. Now, I gave the example of the hire purchase transaction and leasing transactions. In the earlier judgments, say for example, in Mayor Chettiar's case, they said that leasing transactions are not taxable, hire purchase will be taxable at the last end. So the 46th Amendment said that Article 366A will be amended and a hire purchase transaction, a leasing transaction will be deemed to be a sale. So from the 46th Amendment in 1986, all leasing transactions can now be subject to sales tax. There's no problems. Now in a lease, if I take a lease finance, suppose I buy a car for say 10 lakhs and I take a lease and the say monthly installment is 3 lakhs or say 4 lakhs a month is the monthly installment. Now that 4 lakhs may include initially 2.5 lakhs of principal and 1 lakh of interest. Now, according to me, the whole amount is consideration for the sale. You can't now split the consideration and say the principal amount will be towards entry list 2 and the interest amount will be towards service tax. That can't be done, was my submission. Now, you take, for example, the mixture of the famous case of CP and Berar. I sell a car, or let's say I'm Maruti, I make a car. On the manufacturer, I pay excess duty. I'm talking of pre-GST days. On the manufacturer, I paid excess duty, which is entry 84 list 1. On the sale, I pay sales tax entry 54 list 2. What do I pay the tax on? I pay the tax on the selling price. Same 10 lakh car, I'll pay excess duty. Same 10 lakh price, I pay sales tax. Do you say the two taxes are overlapping? Answer is no. One is a tax on manufacture. One is a tax on sale. If I manufacture the car and unfortunately nobody wants to buy it, I still have to pay excise duty. But if I'm a dealer and my car is not sold, I don't have to pay sales tax. Till the sale takes place, there'll be no tax. So there are two taxable events, but the tax is on one sale price. That just Mr. Sirwai calls it subject matter of tax and measure of tax. Subject matter has to be two things. Measure can be one. Take your house property tax. You got a house in Cochin, say for example, you'll be paying property tax. Now they can levy property tax on the area, on the square feet, on the locality, whatever they got, have some rational basis they can have. Or they can say what is your notional rental income. That can be the measure of tax. Now on the house property income, you're also paying income tax. Now can you say these two taxes are same? No, one is on tax on the building, one is tax on your income. The two subject matters are different. Now in aspect theory, you can't take one particular transaction, split it and say it's on the aspect. Like in entry 56 on road transport tax, they say on the passenger service. If entry 56 permits state government to levy tax on transportation of passengers, where's the question of passenger service? According to me, it's not done. And aspect theory, actually, if you see the original judgment of aspect theory, this shortage of time, it all started with a person who was basically running a bar and had billiards. And the law of Toronto said that you can't have a game of billiards beyond 7 p.m. So billiards was played beyond 7 p.m. and he was fined. Some $10 was fined. It went up to Privy Council. I don't know how they could afford that litigation. Now the question was, what is the difference between the Toronto legislation and the parliamentary legislation? Though they use the word aspect, it was basically in pith and substance. They said the Toronto law, barring more than this thing, is basically law and order. They don't want people to drink late into the night, play billiards and create law and order, and nothing to do dominion. Now, aspect theory has been applied in different parts. Say one famous case is there. Aviation is part of the Canadian Dominion, Union government. Land is provincial list. Now, when you make laws with regard, suppose you say in this area, airport cannot be built. Now, in pith and substance, it's a law relating to land. It's not law relating to aviation. They have said in this particular, say, forest area or reserved area, there'll be no activity including aviation. So that's not a particular thing. But you can't then split a law and say that I will put for aviation. Aviation aspect is there, land aspect is there. No. And aspect theory they say applied with great caution. It should be where both the legislatures have the same thing. So my personal view is, you take a hire purchase law, it is pith and substance a sales tax. You take Debt Relief Act, it is pith and substance, a tax for debt relief under Article Entry 30. So don't apply aspect theory, apply only pith and substance, because it creates tremendous amount of confusion. And so many cases we had to fight where they levied service tax on the same thing, which is a sale, on software, on leasing, and so on and so forth, and all were upheld. Yeah. On mandap keepers, it's a building tax on land and building. Now, where then you say no, it's a service aspect. So what they did in works contract is they say 60% will be sales tax, 40% will be service tax. So the works contract is split into labor component and goods component, and that's how it is done. But you can't apply aspect theory for that. Yeah.
Thank you, sir. So another question.
Yeah.
How does the unwritten constitutional principles, as recently dealt with in the Canadian case City of Toronto versus AG of Ontario, compare with the constitutional morality concept of Indian Supreme Court?
Yes. Now, there is one thing, there is a written constitution, and there's always a concept of the unwritten constitution. Lawrence Tribe has written about the unwritten constitution. Mr. Fali Nariman has written a wonderful article on the silences of the constitution. So there are a lot of principles which are thing. Now, for example, right to privacy. It's a classic example of a constitutional right being developed by law and put into our constitution, saying constitutional principles. Procedural due process has been inserted into Article 21. The right to life has been expanded to mean this. So, frankly, I'm not very familiar with the City Toronto facts, so I don't want to comment on it. But I'll speak on the judiciary evolves the constitution from time to time. Take simple thing like due process. It was made in 1789. Now it has gone so many down. It has been expanded from time to time. Like what Justice Holmes says, you meet the felt necessities of the time. So our constitution will keep on evolving into various principles from as times go on. Recently, for example, they struck down the 377. Right? The Supreme Court said it is completely arbitrary. Arbitrariness is a new ground to strike down legislation. Where do you get that? It's again a judicially evolved principle. So, coming to the issue of constitutional morality, in fact, this has been referred to in the 7 judges bench in the Sabrimala case, which again is from Kerala. And the first question is constitutional morality, and we have divided the work among ourselves. I'm supposed to argue on constitutional morality. According to me, again, this is a principle which should not have been introduced at all, as far as we are concerned, is my personal view. What is this constitutional morality? Where did it come from? If you see Dicey's constitution, I think it's part 8, he refers to constitutional morality in the context of constitutional conventions. Like in the UK Parliament, there is no written constitution. There is a tradition that if a party loses a vote of confidence thing, it must resign, must call for fresh elections. Right? So there are so many conventions which are just unwritten principles which have been followed as matter. So he says that it is constitutional morality, you follow that. One court cannot say, like Mr. Boris Johnson cannot say, I will not follow it, I will not do this. He tried to do it and the UK Supreme Court said, no, you can't do this. But constitutional morality was used by Dicey in the context of the UK principles or constitutional conventions. And those of you interested, you must see the famous speech of Dr. Ambedkar, I think in November 1946, 8 November or 1946, where it's a long speech about 11 pages, where he discusses two things. Why was the Constitution of India so long? Because including Pandit Nehru, they wanted a small constitution giving general principles and leave it to the courts. He, in a beautiful passage, he justifies why is it a long constitution. Why has he taken the Government of India Act and made it the longest constitution? He says that the UK principles of constitutional morality cannot be applied here. We are a young democracy. We have so many issues, multiple languages, multiple religions, and so on and so forth, that the constitutional morality has still not set into India. What he meant was basically constitutional conventions. So my interpretation of constitutional morality is it has got no place in the Indian Constitution. We have defined what is what. We have given a very elaborate, detailed constitution. Some conventions have been set up which can be followed, which make amount to constitutional morality. But in one judgment of the Supreme Court, they said constitutional morality can be a ground to strike down legislation, which in my humble submission may not be correct. Just as substantive due process cannot be a ground to invalidate a parliamentary law, I think constitutional morality cannot be a ground to set aside a particular law. So, talking of constitutional morality, I think its origin is UK and it should not be a part of the Indian substantive law, is my view. Sorry, it was a bit long, but I had to give the history of constitutional morality.
Yes. So there's one more question. So what's your take on tribunals being conferred with inherent powers? Tribunals being conferred with inherent powers.
Completely wrong. Inherent powers must be only with the judiciary. And though the matter is now pending in the Supreme Court, I don't know when it will come, but this entire process of tribunalization justice has been a very, very serious inroad into the concept of independence of judiciary, whether it's the NCLT or the other tribunals. I have no quarrel with tribunals like the tax tribunals where there is a litigant and there is a state. In tribunals, which when I argued before the Supreme Court with Justice Ravindran, for company law tribunal, there is no company law tribunal anywhere in the world. You know that? The principle of tribunals is that where it's a list between two individuals, only the courts of that country can decide the issue. You can have tribunals where there's a tax dispute or there is a FEMA dispute between the Reserve Bank and so on. But you can't have this entire concept of tribunals. But this concept of giving tribunals inherent power, the power to punish contempt, is completely wrong. It is anathema to the principle of separation of powers. I think, and the sooner they decide it, they strike it down, the better.
So we'll be winding up the question and answer session now, sir. And I'll be inviting Advocate Sanjay to propose vote of thanks.
And before that, before he proposed, I would like to thank you, Enoch, David, Shyam, and all of the entire team at the Indian Law Institute of Kerala for organizing the lecture. It's been a pleasure. For me, it was a great learning experience. We have had to read so much of material to make these slides. So it was also a great educative experience for me also. Thank you so much. And thank Live Law also for the, thank you.
Yes, namaste. It is a privilege and great joy for me to extend the word of thanks on behalf of the Indian Law Institute Kerala chapter. I deem it a matter of immense pride to convey our gratitude to Sri Arvind Datta, Senior Advocate, Supreme Court of India, for the masterful presentation of the topic. The slides made it all the more interesting and easier to comprehend. We have seen how the question and answer session had enlivened the entire lecture. Thank you, sir, for the masterful presentation.
Thank you. Thank you so much.
The great interest shown by our Chief Justice Sri Manikumar to urge and encourage us to organize such online lectures by the masters in the field is indeed appreciable and would be of great help to the legal fraternity. Thank you, sir. Our Executive Chairman, Justice Alexander Thomas, has been a pillar of strength. Without his advice and guidance, a lecture of such magnitude would not have been possible. I take this opportunity to thank you, sir. I also thank the entire team of Indian Law Institute Kerala chapter, including Advocate V.M. Shyamkumar, whose relentless effort bore fruit. I thank everyone present in this virtual platform. Thank you all.